So panel 4. I'm Mark Eichorn. I'm an assistant director in the privacy division, and I'm here with my colleague Laura Hosken from the Bureau of Economics. So we're going to be spending the next hour and change talking about persistent identifiers. So the fact that you guys haven't left is a good sign. And we've heard a lot about persistent identifiers over the course of the day, and it's really integral to COPPA, one of the more significant changes in the 2013 revision to the rule. And basically, the definition of persistent identifier and the definition of personal information was changed, just so we're all on the same page. The definition now reads, a persistent identifier that can be used to recognize a user over time and across different websites or online services. Such persistent identifier includes, but is not limited to, a customer number held in a cookie, an IP address, a processor or device serial number, or unique device identifier. So one of the main consequences of changing the rule to include persistent identifiers was to bring behaviorally targeted advertising within the scope of the rule. So that prohibition also extends to third parties that have actual knowledge that they're collecting information from kid-directed sites. When the Commission revised the rule, it also recognized that persistent identifiers are used for many other purposes, and in fact, many other essential purposes. So the Commission created an exception to allow the use of persistent identifiers for support for internal operations, when that's the only type of personal information covered. So a lot of our discussion in the panel will focus on either the concept of persistent identifiers or the concept of support for internal operations. So just a reminder, comment cards are available here in the auditorium if you're here, or you can submit questions by email or Twitter. And because the panelists' bios are available, I won't go through their histories, but I was going to let each person have the opportunity to say where they're from and introduce themselves. James, do you want to start?
Yeah. Hi. I just recently left a stint here at the FTC, and I'm back at George Mason Anton Scalia Law School teaching it again.
Hi. I'm Harry Joe. My wife and I are the creators of Mother Goose Club, one of YouTube's earliest kids channels.
Hi, my name is Katharina Kopp. I'm with the Center for Digital Democracy, and for those who don't know, Center for Digital Democracy represented by a large coalition of child advocates and a broad coalition, and supported by Georgetown's Institute for Public Representation. We were the ones who led the charge to get COPPA passed in 1998, and also we were the ones, as part of our coalition, who really pushed for the broadening of the definition of personal information to include persistent identifiers.
Hi again.
Hi, I'm Kate O'Loughlin from SuperAwesome. SuperAwesome is a kid tech company, so we're providing products, services, infrastructure to ensure safe engagements with kids when they're online.
I'm Julia Tama. I'm a partner at the law firm of Venable, LLP.
And I want to thank Jonathan again for kicking off the presentation. And I want to thank each of you panelists for sharing your time and expertise with us today.
So we want to start off by talking about both the pros and cons of collecting persistent identifiers, and we'll start with the cons. We're particularly interested in how these might have changed since the last COPPA Rule review, since 2010. So who would like to start? Katharina?
Sure. I think it's important to remind ourselves how important it was to have persistent identifiers included in the definition, because everyone in this room and everyone above 13 and older in the US today is subject to constant surveillance and programmatic behavioral data collection and use practices on all their devices all the time. This is a growing privacy problem for all except for children, which are protected by COPPA. And so really persistent identifiers are the foundation for behavioral and programmatic advertising. And today, as a result of this rulemaking, we do not see sort of this programmatic advertising options in the programmatic space. But of course, we see a lot of non-compliance still because it's not being enforced properly. And also we see the problem for teens and generally for adults. So really the children are the only Americans today who are not protected in this way. But before I go into some of the negative impacts, I just want to also remind ourselves why privacy is important. I think it's, we sort of maybe lost a little sight of this, why it's important for all of us. We here believe that privacy is a fundamental right. It's not something that should be negotiated in terms of pros and cons, right? It's a fundamental right. And where trackers or persistent identifiers are used, that right is typically undermined. And so I'm talking here about loss of autonomy, decision-making, integrity of individuals, loss of dignity, loss of seclusion, the rights to seclusion, fair processing of data, really increase in undue manipulation, so that's the use of information technology to impose hidden influences on users by targeting and exploiting their vulnerabilities. And as was mentioned in the previous panel for the first time today, privacy is in our mind also a civil right. So any denial of equal opportunity and unjust discrimination can also come from violations of privacy rights. So these are really all sort of, in our view, cumulative negative effects that impact the individual, and of course there are societal negative impacts that I'm going to skip out for, but to mention increasing inequality, we believe, comes from undermining privacy rights, and really, as we've seen in the last elections, undermining of democratic institutions with voter suppression. But specifically with regard to children, and I'm going to expand a little bit more, I think we have to understand that privacy or the use of persistent identifiers, really, we have to look at this as a very intertwined space. We have marketing, we have children's content, and we have data collection. All these are sort of mutually integrated. And so we have to understand the entire ecosystem to understand why persistent identifiers are harmful. So really at the beginning of childhood, in the very early stages now, marketers are trying to attract the attention of children, to develop content, entertainment for them so they can collect more information about them, so that they can deliver audiences to advertisers. So this has led to an increase in more and more content. We've heard more and more devices, more and more sophisticated ways of collecting information and hooking children to content and entertainment. And so specifically, my organization has looked a lot in terms of, was mentioned earlier, and for example, in fast food and other unhealthy foods and beverage marketing and advertising to children who are particularly vulnerable with this regard. We are facing a childhood obesity crisis of epidemic proportions, and the impact on low income and youth of color is particularly high in this area. And then, of course, there are related costs to state health and federal health care. So all these are sort of negative impacts of it. Then also child psycho and social development, impact on the family and social interaction. We didn't hear that much from Jenny this morning specifically on this, but there's a lot of research. Obviously, that was the reason why the Center for Media Education at the time was so concerned about it, because there was a lot of research that suggested the harmful impact on children. And we see more and more evidence that industry is experimenting with cognitive and behavioral insights, taking advantage of children. There's been some evidence from Facebook, for example, that has been experimenting with allowing advertisers to target vulnerable teenagers at moments when they feel worthless and insecure. I, for one, as a mother of an 11-year-old, I'm particularly alarmed about that. So we don't really know where the long-term impacts are of these kind of practices, and we really should think about it as really as a precautionary principle, not doing harm, and we should spend a lot more time in research in looking into this. There's, I think in Congress, there's proposals to do more research into this space, and we would encourage the FTC also with its authority to really understand the impact of these practices on children.
And anyone else?
Sure, I'll jump in, and I may be surprising that I have a slightly different view than Katharina, but those who know me chuckle. So, no, I agree that the issue here, you know, the surveillance issues that are facing everyone are the same that are facing kids, and I think we should start. And it seems that there are two types of harm that COPPA seems to be targeted at least in some ways, and one is the actual just advertising to kids, which I think is a different animal, and maybe we can talk about that more, because I think that's quite different. But I want to think about it more as the privacy aspect. There's surveillance, and I think that when I don't think as policymakers we should be able to just say, well, privacy and kids and then be done. I think we do need to think in the same way that we think about surveillance and online and privacy issues in the grown-up world, the same way with kids. And what is the harm that we're talking about? What is the injury? Because as we'll talk about later, there are potentially costs to restricting persistent identifiers. So when you look at as far as I know, there's not a lot of evidence as far as privacy preferences for children. All of the data, the empirical work that I'm familiar with, it deals with adults. And so if you look at whether it's the experimental evidence or if you look at field experiments, in revealed preference, there are a few studies seem to all suggest the willingness to pay for privacy is relatively small. I mean, that's again grown-ups. Now, there are informational issues, there are behavioral cognitive biases, but even when there are some studies that try to control for all of that, and at the end of the day, it seems to be what's out there, and this is a conclusion that there's a survey article by Queefty, Taylor, and Wagman on the economics of privacy, and they conclude, if you look at the data, that it's pretty clear that the the consumers seem to be more engaged in privacy-reducing activities than privacy-protecting activities, and that there's a very small willingness to pay for privacy. Now, we can debate over, you know, again, there are flaws in each of the studies or in some of the studies, and but I think the takeaway there, and then especially when you look at what we're talking about here as far as persistent identifiers to target ads, that usually ranks, even in survey, which is stated preference, as a relatively low-level concern compared to other types of privacy. You know, it certainly does concern people, the creepy feeling of being tracked around the web, but again, it's usually not the top-level concern. So when we think about what are the harms that we're trying to address? Now, that's the grown-up world. Again, there isn't any data, and I could imagine, kids are more vulnerable, and if the profiles that are put together on kids were similar to the ones that were put together on adults, which would include other PII, such as name and address, all the gender, all the sort of profile information, but if we assume that, say, a company is COPPA, an operator or a website is COPPA compliant in every other aspect, and then we go back before persistent identifiers were called PII, if you're COPPA compliant in every other aspect and all you're doing is putting a cookie, a persistent identifier, or other type of persistent identifier on a device, it's unclear whether the type of surveillance would be the same. I mean, because you're not going to be able to link it up with all the other types of information. You know, it's clear that when you have a Google account, Google knows a lot about you because you've signed up for that account. If you're a kid and everything else is COPPA compliant, the persistent identifier won't be linked up with those other things. So I think we have to think about what is the harm that, going back to 2013, what is the harm that persistent identifiers are trying to address from a privacy standpoint? What is it really, what is the privacy harm, and does it rise to the level that we're willing to impose the cost that again we'll talk about? And I think in some ways it comes back, putting on more of a lawyer hat and less than an economist hat, to think about the debate that went on when the COPPA rules were out, and thinking about what does contact a kid mean, or and is a behavioral, you can't collect PII as something that can be used to contact a kid, and is a behavioral ad contacting a kid. And I thought it was wrong then. I still think it's a wrong interpretation now. And I think as you go back to the drawing board, maybe that's something to reconsider. So anyway, I'll leave it at that for now.
James, I'd like to disagree a little bit with the idea that collecting a persistent identifier in a single website cannot be connected back to other bits of PII which are more sensitive. It's one of the big differences between what the environment was like, the ecosystem was like in 2010 and 2011 to what it is today. The invention in the adult side of advertising technology has really leapfrogged in terms of the ways that a single person can be identified and re-identified and their data connected together. Back in 2011, there weren't things called customer data platforms, customer management platforms, data management platforms, which are all places in which disparate pieces of information that seem innocuous alone are now combined together, and they are prolifically used across all content monetization platforms and across all advertisers. So even though it might seem a bit innocuous to drop a cookie on a kid when they're on a single website or from a single advertisement, do know that there are many, many systems out in the ecosystem that can connect that cookie back to precise geolocation, or can connect that back to a user screen name that then can be connected to people's preferences.
Well, I was going to say, otherwise COPPA compliant, user screen name and geolocation would not be COPPA compliant if those had already been collected. So if you're otherwise COPPA compliant, but for the cookie, that's right. I mean, and I will grant you, I don't know the tech space the way that you and Jonathan do. So that's what I was saying. So I think both, if you add either one of those pieces of a kid, it would have been non-COPPA compliant unless there was parental consent.
So I think my point is that a single site or a single advertisement might think that they are innocuously just setting a single browser, but when they connect it to a third party or they let that be used in some kind of internal operations allowed environment, that is going to be prolifically sent out to a hop and another hop and to another hop to another company that can connect it back to something more sensitive. And what we've seen since 2011, 2012, that some of the mechanisms that we've tried to put in place to prevent that downstream or upstream connection haven't really worked. So some of the flagging mechanisms that are used in the advertising technology space, the things that we're hoping to send out as signals that this piece of data shouldn't be used in connection with anything else, haven't yet worked. So as we look forward, we need to make sure that we understand that these systems are already in place and very widely used, and we have to make sure that we don't introduce additional exemptions that let them be exercised with even more collection and connection together.
I have a question. Do we know if that data actually is being used to target not children generally, but presumably, let's say, children under the age of 8, right? Are they using that level of targeting in order to present ads to children under the age of 5, for example, right?
I don't think you would find anybody that would raise their hand and say we are using it.
But I wonder actually, if, just from a common sense perspective, knowing there's so many ways to otherwise target children of that age, right? And if you are, for example, marketing, junk food, you don't necessarily need to go to those lengths, right, to provide that, to deliver an ad, right? So again, I personally don't know. I do not run an operator, but I wonder, as we think through this, and the FTC is doing its research, if that's something that we should be looking at, right?
Yes, I do. Sorry, I'll just jump in here one more time, that yes, it is possible to advertise to kids without it being data-driven, without using personal information for the good, not just the bad example you're using on healthy food. And I think that's earlier today, that was one of the sort of a bit frustrating things to be sitting in the audience and hearing, is that if we don't let data be part of the equation, then the entire kids ecosystem is going to collapse on itself because data is the only way to make money. That is not true. There is safe and effective advertising that can help great kids content creators monetize that do not have to be data-driven. We do that. We see that every day. In our technology, we are proactively stripping out data so that we can have safe ads, we can have safe engagements with kids, and it works phenomenally well. The big kids brands, they want to talk to kids, they want to do that safely, and it can work data-free.
I think maybe that brings us back to the question of the pros and cons, and if I could jump in on the pros at this moment, I think that this is something that the COPPA Rule today actually recognizes, right? Persistent identifiers are defined as personal information, but there is also this important exception that's been mentioned about support for internal operations, and that exception is the piece that makes it workable to have persistent identifiers as part of the rule. Because if we're talking about the pros, a lot of those are recognized in the exception, right? Persistent identifiers are absolutely necessary for a lot of functions in online services and websites today that make them interesting and engaging for kids, and the exception, sees that. So. And the exception also recognizes, I think, that persistent identifiers are a bit different from the other types of personal information that are listed in the COPPA Rule. Persistent identifiers do have these beneficial uses. Other data also has beneficial uses, but persistent identifiers are allowed to be used for certain purposes without parental consent because of those beneficial uses. So I think there are a lot of pros, and I actually think it's very helpful that the COPPA Rule is recognizing those today. And I think that it's essential to maintain that exception and to continue to work towards improving it and keeping it as clear and as comprehensive as possible so that it can continue to be used. And it really is for the benefit of kids to make sure that there can be engaging and interesting online content for them.
Julia, have you seen an increase in benefits over time since the previous rule review? I mean, has this gotten more useful for internal purposes over time, or is it kind of just the same? Do you see that?
I'm sorry, are you saying that persistent identifiers have become more useful over time? Is
For
that the
internal
question?
purposes, yeah, for designing apps? Or maybe it's not something you've thought of.
No, it's a little bit hard to answer, I think, over time. I mean, I think what is listed now is probably the minimum of what should be listed of support for internal operations. The challenges that I see as a practitioner are that there's still uncertainty. So there are services or functions that companies might like to use persistent identifiers for, which are not behavioral advertising and are not profiling. But if the rule is uncertain, companies are very risk averse. And so there's a chilling effect where the exception is not clear.
Katharina, I know you had wanted to wave in, and then Harry.
Sure, thank you. Yeah, so I think with regard to the internal operations exception, we believe that the definition is way too broad and vague, that it really creates incentives for operators to claim that persistent identifiers are used for internal purposes, even if they're not. So, for example, the content personalization exception, we believe that sometimes content personalization is similar to personalized ads, especially when ads are, or for example, content on YouTube are really ads. So you have branded channels, for example, on YouTube. If a child sort of clicks on that, it likes that, and then the personalization would basically repeat sending that content to the child. And that sort of really amounts to, more advertising for the child to be consumed. And I also think that content personalization, I think we're going to probably see much more of that. And, you know, I think you've been involved in the research on dark patterns in e-commerce websites. I think dark patterns, so this attempt to have the design architecture so that certain default decisions are made by website users, we're probably going to see much more of that being personalized. And so there's forms of manipulation that's going to creep into sort of making that, so the children making choices that they might, you know, give away more information, or that they will be manipulated in certain behavior. So this exception for internal operations, I think we need definitions for that. We need to understand what companies are doing with this data. So again, I think a 6B authority would be good here to really understand how companies are using this information under the exception. We also have concerns, for example, around the use of this data for attribution and measurement purposes, because that would facilitate advertising and marketing. And I think that's not the purpose and the intent of COPPA.
I just want to jump in on that for a moment and say that I think we have to be kind of disciplined about this conversation, because there's a lot of concern, of course, you know, at all times about what advertising or what content kids are seeing online, and that's an important conversation to have, but I don't think that's a COPPA conversation. COPPA is about data collection from kids, and then we've introduced use restriction in the form of the support for internal operations exception. So I think we can speak about it there, but I do not think we should try to make COPPA into the vehicle for all policy concerns that might relate to ad content or content online for kids.
Harry had wanted to jump in.
So I'm not an expert on COPPA, but you know, to the extent that when I look at, say, where we sit with the data that we have access to for our audience, we get data from YouTube, we have an app out there, a subscription app that we have data from Apple, and then we have data from our website. Apple and Google do not provide us with really anything that's even remotely at a user level, but there is important data there about the geographic locations. For example, we have a large international audience. Knowing that we have a large Latin American audience led us to create a Spanish channel, right? We wouldn't have known to do that if we didn't have that data, right? And you know, I'm sure cookie level data came into play, but by the time the data got to me, it was aggregated only at the country level, right? Which was really all the data that I needed. So one element here, I think, is who is looking at me, meaning there's operator level data at Google's level, and then there's the data that we get, meaning, you know, on my website, I might get more data, but I don't necessarily need to look at data to that degree of specificity. But it is essential for me to be able to provide content, to have access to some information other than fan email of what we are, who our audience is. Similarly, you know, with Apple, I mean, where we have a subscription app, I would say that just anecdotally, going to the issue of harm, I would say the number one bit of feedback, we go out of our way for our content to provide ad-free experiences. So yes, we're on YouTube, but we're also on pretty much all of the subscription video services, and we have a subscription app, which is ad-free, and then we've removed all ads from our website. And yet, in spite of that, I would say the number one bit of feedback we get on our app is, why can't we make it available for free? If we had, you know, we don't really consider it an option, but I would say that our audience would probably want to have an opportunity to somehow opt into ads instead of paying the subscription fee. So as we think about how these identifiers are used, I wouldn't want the conversation to be about just one level of operator, or that the audience for the data would just be only advertisers, but rather there are many different audiences, and not all of them have to get that data. I would never want to have, or would never need to have, user level data on anyone. We have millions of fans, and that would just be not useful for us, and I think most people wouldn't have an interest in that. But certainly, we would need to have data. You know, going to one of the earlier panels, and we worked, you know, when we developed our app with one of those with one of the app companies, TouchPress, and many of the other companies listed on that slide are no longer creating content for kids. They're you know, one of them was acquired, the other one went out of business, and that was the cream of the crop for content in the app space. So when you look at the preschool app market, that is absolutely a market where you're seeing a negative impact as a result of being able to have monetization options. The result then is that we all know that people continue to stay on these devices, so they are now using apps and engaging with content that is less thoughtful, not created by people who are even aware of COPPA, et cetera.
Jonathan, I know you had your hand up.
Thanks. So I guess to respond to a few points that have come out from a technical perspective, the first one being, why should we care about these identifiers in the first place? And I think often the conversation tangles the use of information with the collection of information, and those are related but distinct issues, right? So you might be concerned about behavioral advertising to kids, or, not mutually exclusive, or, you might be concerned about third-party entities collecting information about what kids do online. The rule could get at one of those or the other, or both of them. I think as currently drafted, it gets at both. As for why you might think it's not cool to have a company you've never heard of collecting your kids' activities online, I'll maybe leave that to others to talk about. The second point I want to address is this monetization issue, and whether you can monetize an app if you need verifiable parental consent to do behavioral advertising. In other words, we don't have, or I should say, we don't accommodate quite a bit of, I'm sorry, I should say advertising with an identifier, third-party advertising. As a technical matter, there are a bunch of other directions you could go. So there are other types of advertising outside of behavioral advertising. Some have been mentioned today. So demographic advertising, that's, we think we know something about this kind of person at a very high level, but not specific to the person. Right, so people who are playing an app that in an app that is designed, let's say, for little boys or little girls, you might target based on that demographic information without knowing something about the specific user. You could have geographic targeting, not precise geographic targeting, like based on GPS, but this user seems like they're in Washington, D.C., so we'll advertise a kids club in Washington, D.C. Or you could have contextual advertising, right? So the kid's in an app where you're at the dentist's office, and there's some app related to like some fun toothbrush. I don't know what at any rate, the point being, it could be based on context. So there are a bunch of different ways of targeting. There are a bunch of different ways of delivering ads, right? So instead of using identifier, you could imagine an ad delivery that's stateless or that uses some state stored in the device rather than using a unique identifier. You could use a session identifier, so a short-lived identifier. You could use first-party identifiers that are persistent, but not persistent third-party identifiers. So there's this entire spectrum of designs, short of sharing persistent identifiers with third parties for all advertising. And at the risk of putting too fine a point on it, Apple has effectively banned third-party advertising that uses a persistent identifier in the App Store, and clearly the App Store is doing fine in terms of having children's apps. And so, the claim that that an exception for that type of advertising is essential seems a little bit belied by the Apple experience. The last point I want to make, and I recognize I've been talking for a bit here, relates to this internal operations exception. And I think the exception kind of conflates a few things that might be going on. One is to say, we're concerned about behavioral advertising, so we're going to cover behavioral advertising and then use the internal operations exception to exclude everything that's not behavioral advertising, right? So the only persistent identifier stuff we're trying to cover is behavioral advertising. I don't think that's what the rule's trying to do, but that could be, a direction some folks either want to go or conceive of it as. Another is the sort of bare minimum for the app to function. And that, is like network level information, right? You have to be able to collect IP addresses in conjunction with the app loading, otherwise the app can't load anything. And then you've got this broad middle of stuff where I believe the term used in the last rulemaking is smoothing the internet experience or something like that, right? Where as a sort of accommodation to the ecosystem, we're going to allow identifier-based contextual advertising, other forms of advertising, frequency capping, et cetera. And there, I think, is where the hard policy questions is, and I think it's a little bit of a misnomer to call it internal operations. Again, I think it's a sort of concession to allow the ecosystem to run, and query whether that form of concession is technically needed at this point.
I believe Kate wanted to step in, and then maybe we can change the discussion just a little bit.
Yeah, sure. So the techniques that Jonathan described for delivering advertising without data are all right on. And what we see practically is that the ecosystem can thrive using those techniques. Those same techniques and those same paradigms can be also applied in measurement. Some of the internal operations expansion ideas have been maybe around attribution. If you're not familiar with the term attribution, is connecting whether an ad drove to something being sold. I think it seems a bit innocuous, and it is important to marketers, so it might be one of these places where concessions you might have a lot of pressure to concede. But let's remember that what is attribution or what is marketing measurement to some of the most active brands in the ecosystem might get us too close to data that we really think is sensitive. So if you think about Target or Walmart or Chuck E. Cheese, what matters to them in measuring whether or not advertising worked is, did someone actually walk into a store? And so if we extend some of these internal operations to include attribution as a use case in measurement, we again are getting into this territory where we're connecting a bunch of data together that gets even more sensitive. And we can accomplish measurement, we can accomplish marketing effectiveness measurement, which is ultimately the job that many marketers want us to do, by using some of the same techniques that Jonathan described on the targeting side of advertising.
James?
I just wanted to, jump in and just say something that, we can look and say that advertising ecosystems app ecosystems are thriving, but what we don't have is the but-for world. The one thing we're looking at it, and I agree. You look at the App Store, and there's absolutely no dearth of children's apps. But what we, just from a good empirical standpoint, just to look at something and say there's a lot, so there's no impact. I think there's clearly an impact. First, there's just anecdotal. Harry talks about going behind a paywall. So that's one thing. We know if you go behind a paywall versus ads or have a freemium type view, demand curves slope downwards. So you raise the price, fewer people consume. That's just going to happen. The second thing is the data, the empirical evidence is pretty clear that behavioral or interest-based ads, or whatever you want to call them, they do garner more revenue for the content creators. In fact, Garrett Johnson at Boston University, Catherine Tucker and Avi Goldfarb, they were actually down here last fall as part of the Competition Consumer Protection hearings. We had a whole thing about that. They're somewhere between 2x and 5x, maybe 10x, depending on for the revenue. Now, there is some evidence to suggest that maybe that's overpriced, that their effectiveness isn't what they are. But just as far as the revenue that's generated, and in fact, all you have to do is read the commission statement in the YouTube case and look at the YouTube statement after that, knowing that it's going to harm, talking about how YouTube profited off of these ads, and then then YouTube saying, look, we know this is going to be tough for some content creators. So it is going to say that what would be good, and maybe this is something we'll talk about later, because I know we were going to talk about what the next steps, what are some research, to actually see what the impact of the 2013 rule was on kids' content. And again, we could look at it and say it's fine. And I have kids, and I think they have plenty of apps. Probably too many. But just from a good kind of science perspective, to see, has there been an impact? And the impact can be not just some disappeared, some may go behind a paywall. There's also content. There's a good, very recent paper in the Rand Journal of Economics, Joel Wadfogel and a couple co-authors, and I apologize to the other two co-authors for forgetting their names, but it's not exactly on point, but it's about ad blockers. And they find that for every percentage of your audience that has an ad blocker, your revenue goes down by about 1%. And that also, when you look at the heaviest trafficked, the sites with the heaviest ad blocker traffic, they have less content. And so, I think there definitely is, there's likely to be some impact. And again, maybe the world's fine, but I think that we should think, we can't just look at it and say that there's enough out there and there are lots of ways you can monetize, but you are changing behavior. And I'm not saying, again, and I just want to say, this is just something that needs to be weighed. Maybe this is the right equilibrium. Maybe there's a market failure. Maybe we need government intervention here. Maybe COPPA's the right balance. But we can't just look at it, the Apple App Store and say there are lots of kids' apps, so it's fine.
If I could, I just want to quickly say, you can actually tell, at least in the preschool space, you can see sort of the vision of the future on content where, say, 5, 6, 7 years ago, you had many independent companies developing content. So for example, when my kids were really young, they played Tocoboga's apps. They loved them. Now what you're seeing is the developers are focusing on brands that are basically using the apps really just to promote, mega brands. So like the Disney apps, the Lego apps. But those independent apps have pretty much largely disappeared unless they're basically, there's a large group of, we'll call it almost disposable apps that are being cheaply generated at scale, right? But that sort of very thoughtful kind of independent creator base in the App Store has largely disappeared, right? And more likely than not, you might see something similar happen to YouTube, right? So there is actually impact. There's meaningful impact, and it will affect choice.
So I think you guys got through several of our questions without asking them.
Can I just jump in here for 1 second? Just in terms of framing, I think that's been bothering me a little bit this morning already. I think we're not here to do a sort of a balancing act, right? COPPA had an intent to protect children, to limit the contacting of children, the limiting the marketing to children because they are vulnerable. And there's a lot of research out there why we care about children. As a society, we've decided we care about that. So we should not sit here now and sort of decide, okay, what's the negative impact of businesses and how do we trade this off against children? I think the priority is that we want to protect children, and that's why we have COPPA. And so I think there are other times when I think it's appropriate to consider what the trade-offs are, but not in this particular case.
I don't think it's businesses or children. I think it's businesses and children. Businesses are out there wanting to offer high-quality content to kids, businesses of all sizes, as we've heard. And I think I'm a parent. I think we want kids to have online content. I think we want them to have access to this tool, the internet, that is going to shape so much of their lives. And the question is, how do we do that responsibly? And just to tie that back to one particular aspect of the COPPA rule, because it's just come up a lot, there are limited options for monetization to support publishers who want to offer that content to kids. And contextual advertising is a really important one that is recognized in the current COPPA rule. And so I would just say that one way to support businesses and children is to continue to recognize that exception for contextual advertising, including the activities that come with contextual advertising. I would certainly include ad attribution in there, and I'm sure there will be other ideas in the public comments in terms of things that should be considered part of meaningful contextual advertising that can support an app or services for kids.
So to that point, I'm just going to interject right here. I'm sure you guys could take care of it yourselves. There is an open question as to whether or not behavioral advertising brings in significantly more revenue than contextual. And I just wanted to hear from everybody kind of what their experience with this is. If you have no idea, you can just say, I have no idea. That's perfectly reasonable. James, you've already answered this question.
And I won't talk.
So I'll start with Harry.
Sure. I would say currently we get advertising from, or revenue from quite a large number of sources, but I would say that behavioral advertising on YouTube constitutes the lion's share of our revenue. I would say the loss of it will require us and every other YouTuber in a similar position to dramatically change their entire business model, which we're in the process of doing.
So I think the questions that were raised around this issue, also with the research from Professor Akristi, I think only point to the fact that we need more transparency around this and what the role of the platforms are in determining price around that. So again, I think 6B Authority is called for here to look into that, what the really the behind the scenes information is.
I agree with the call for ideally the commission to do work of its own and certainly to encourage more work in this area. It's an area of research I've wanted to get into. It's essentially not possible because the entities that have the data are generally not really overly enthusiastic about collaborating with privacy researchers. The work that has been done to date, I think, in many instances has some serious methodological issues, and I say that about the work that finds that behavioral advertising is quite valuable and the work that finds behavioral advertising is not so valuable. And so I genuinely do think we just need more research. And it is a little crazy that we're a couple decades into behavioral advertising, like driving much of the online economy and privacy conversation, and we're really not super sure just how important, or actually how necessary this stuff is. It's a little weird.
Our experience is that safe kids advertising commands equal prices that advertising to adults that's very data-driven does. We don't see a gigantic discount to contextual advertising. And then when it comes to the changes that is going to be incurred for monetization by content creators with YouTube changes, I would just say, let's not muddle turning off data-driven advertising with some of the more structural changes that they're making to declared kids content. When they turn off comments and when they turn off engagements, that's affecting their algorithm and how users are going to find that content. That's one part of the expected decrease in monetization, which is separate from just turning off the data in the targeting. So let's not conflate decrease in prices or decrease in revenue to kids content creators on YouTube just because the data is turned off.
Agree. Julie?
Julia?
It's my understanding that there are plenty of studies showing that interest-based advertising is more supportive for publishers than contextual. I certainly think it's, we can always have more research. It's a data-driven industry. We can have more research on it. Certainly, that would be welcome, but I do believe that there are plenty of studies showing that the results for publishers are better with the interest-based advertising. And I think that's what I hear anecdotally. Of course, under the new COPPA rule, there's been a shift in that in the past 6 years. So that was, more from the time that the rule came out that we were hearing those concerns.
So I'll ask a question from the audience, and sort of gives me an opportunity to address something I've heard earlier today as well. So the question is, as Commissioner Phillips noted, looking at the intent of Congress, COPPA was about addressing contacting of kids. Does the persistent identifier alone allow contacting of a child, assuming it's not combined with other types of information? So I just wanted to take this opportunity too, since we're talking about the intent of Congress, and people have talked about the intent earlier in the panels and basically talked about the online safety aspect of congressional intent. But when you look back at sort of the FTC report that led to it and to the, I think, to the statute and the original rule itself, I think that it's clear that there's a couple of purposes, and one was online safety, but I think the other purpose was to basically restore parents to the role that they used to have back in the day, where the parent would be home, and if you wanted to reach the kid, you would be calling, and probably the parent would be picking up the phone, or you'd be sending some mail that the parent would be, reviewing. So from the legislative history that was from, I think, Senator Bryan, and I think he was speaking for himself, and Senator McCain, he spoke to this issue a little bit, and so he talks about the information being collected, and then at some point he says, much of this information appears to be harmless, but companies are attempting to build a wealth of information about you and your family without an adult's approval, a profile that will enable them to target and to entice your children to purchase a range of products. The internet gives marketers the capability of interacting with your children and developing a relationship without your knowledge. Where can this interactive relationship go? Will your child be receiving birthday cards and communications with online cartoon characters for particular products? So that's just an excerpt, but sort of gives you a flavor of, you know, online safety was just sort of part of what they were after. But anyway, I sort of provide that as background, but the question is sort of going again to, does the persistent identifier alone allow the contacting of a child? I think James has.
Again, I think I've already answered that. I just think, I mean, you're right. And I actually reread the legislative history as well, and you're right. And I think that there is this sort of conventional wisdom that COPPA is about protecting kids from predators and that sort of thing. But you're right. I mean, it's clearly in the germ of COPPA was also advertising and marketing kids. But I still think if you just look at the statute, and the statute says, you know, any under PII, it can be any other, and I don't know it verbatim, but you know, any other thing that that can help contact I don't know if it says specifically contact a child or. I still think that it's I agree, and again, this was all in the comments. I mean, you guys went through this and you worked through it 2011 or 10 through 13 or 12, and that view did not carry the day, but I still think that it's a stretch of the statutory language because to say that a advertisement is contact an identifier that allows you to send an advertisement is the same type of contact as, you know, the other things that are specifically in there, the email, email, address, phone number, name, birth date, those sort of things. So I would say just as a matter of statutory interpretation, I think it's a little bit of a stretch. But again, that was already. If you want to go back and rethink that, in fact, recent case on net neutrality said it's okay. You can go back and rethink your rules. So just because you think you got it wrong the first time. So.
And the original definition that James is referring to for persistent identifier was any other identifier that the commission determines permits the physical or online contacting of a specific individual. Did anybody else have any thoughts on this? Jonathan?
So let me just quickly give, again, I'm trying to stick to the computer science here, so I'm not going to talk about Chevron deference. But from a computer science perspective, an identifier is like how you contact people or devices online. I mean, ultimately, it's the reference to, again, whatever person or device you're trying to talk to, and then you resolve it through some underlying protocol. For email, we have a suite of protocols like, you know, SMTP and so on. For phone numbers, there's all sorts of protocols like SS7, and for a cookie, we use HTTP. But ultimately, these are just always of placing something in front of a person or getting some information to a person. And again, from a computer science perspective, I don't see any difference between these communication technologies with respect to whether one is enabling contact or another.
Julia?
From a practitioner's perspective, there's a very significant difference. And I think we see it, I mean, we heard some of this earlier, you know, persistent identifiers are being added to more laws as a type of personal information, and it creates a tremendous amount of mischief for companies. It's extremely difficult. It's very easy to say it's an identifier like any other, but the fact is it's a different type of identifier. It's a identifier that does not allow me to pick up the phone and call a child and speak to them in real life. It is an identifier that does not allow, you know, that doesn't give the same ability to go back and you know, engage in some of the activities that some of the new laws are calling for, like access, et cetera. So it's just important to realize that persistent identifiers are categorized as personal information today under the COPPA rule, but they remain fundamentally different from the other types of things that are listed as personal information. And that exception on support for internal operations, that's why it's so critical and essential for it to remain in place, is to recognize that difference and to make it's what makes it workable to even have persistent identifiers in there. And I would agree with the comments that I do think it's a stretch to have persistent identifiers in there. I don't think they allow contacting in the same way as the other items in the list of personal information. But if they were to be left in the COPPA rule, the exception is essential, and it needs to not only continue to stay there, but continue to be improved and to offer more clarity and more certainty for the companies that are really relying on it.
So we have another question from the audience. Most monetization concerns mentioned today are centered around advertising. What does COPPA have to say about paid subscription apps or businesses? Harry? You're the paid subscription guy.
Right. So it's, with our app, we've designed it to, we use the service to make sure it was COPPA compliant. And the irony there is, and we actually have no direct relationship with our users, they subscribe through Apple service, so they're completely invisible to us. I would say that from that perspective, one of the issues that does come up is, and it's been alluded to sort of when you, from a product design standpoint, you do want to consider, if the original purpose of COPPA was to prevent that level of, you don't want people to like call people up in their homes, should it also prevent me from allowing them to have a playlist, right? There are many, I would say nearly all of the product services that people would want are services that would require a certain amount of customization to their use. But for us, we'd either have to do it for everyone or not at all. And so the answer ends up becoming not at all. But in the ecosystem where the digital ecosystem of today, the fact of the matter is that the users have been so conditioned to not paying for content that a subscription app is really almost something that we invested a lot of time and effort in it, almost as a loss leader, I would say as a matter of principle. It's not a major driver of revenue for us, right? Almost all the major drivers of revenue for us are advertising based, and that is because, and that's what the audience wants and demands. And I would say that, and we've heard the word equity today, for most of our audience, they would consider that a very serious issue of equity, right? Like if I told them that the only way to consume our content was for you to sign up to a subscription service, I think most of our fans would consider that to be very offensive and outrageous. So, which is like, I don't personally support tracking, kids to that level of detail. I think that a certain level of specificity, there's, from where I see it, like, why would you need to get beyond a certain point of information? But if the information is anonymized to a certain point, why shouldn't you be able to use it to provide a better experience? Why shouldn't you be able to use it to also support ads if the advertiser and the users want that, right? It's the only way, quite frankly, for a robust content environment to exist. Otherwise, we would ironically end up in a situation where, thanks to regulation, you'd be creating content monopolies where only the biggest billion-dollar content providers could deliver content to this audience.
Anyone want to comment?
So I guess a point that occurs to me in response is I think everyone wants there to be free, awesome content available for kids. That's like a lot of the promise here. And one of the directions that strikes me is potentially promising, and that I hope the Commission will take the opportunity to explore, is addressing this issue of age gating and parental consent and oversight via platforms. So I think one of the issues we have now is if you want to be a content creator or a developer, the sort of model is the burden is heaped on you to figure out the age gate, to figure out the parental consent, et cetera. And you could imagine a world in which platforms, especially as the data show, kids are overwhelmingly moving towards a small number of mobile platforms and they're using tablets on those platforms. If those platforms did a good job of implementing age flagging, age gating, parental consent, et cetera, it might take a lot of the strain off of app developers and content creators who have to roll.
Yeah, absolutely. Yeah, I think there's a way that we're talking about data where there's just one pool of data and there's one group of people that want to use that data, and that's not actually true. There's a wide range of data, and there's a wide there's many different constituencies that want access to some of that data. I would say I struggle to think of anyone who actually wants to get to that level of specificity for children, right? And certainly we shouldn't allow anyone to get so much individualized data that they could actually call someone up in their home. But at the same time, between that and being able to give anonymized data to certain classes of people and allow them to support advertising, allow them to support app development, I don't really see a public policy interest that's addressed there. It's totally anonymized. It may not even be from people in this country, right? Especially if we're talking about YouTube or the App Store. So certainly there seems to be a wide sort of middle that we can bridge as we look into this. I would just urge that as we do the research, we do it somewhat quickly because starting Jan 1, a lot of us might not be around. Yeah.
Can I ask, sort of changing the conversation just a bit, one objective to online advertising, we've heard about it earlier today as well, is that really an objection to the content of the ads themselves or to the products advertised. So I remember a few years back there was erectile dysfunction ads appearing on the Super Bowl, and there was a lot of talk about that, or generally on football. Is there any connection between that and, like, if I'm a kid site and I say, you can't do OBA on my site, is there any connection between that and appropriateness of ads? Either am I more likely to get ads that are appropriate for kids, or am I less likely to get ads that are appropriate for kids, or is it sort of no relationship there?
I think that it should be every person or every company in the ecosystem and the ad delivery chain's responsibility to make sure that a flag telling you that this is a kid should mean not just don't use or collect data here, but also make sure that this experience is appropriate. What is the kid hearing, seeing, feeling, should abide by the guidelines set out by the self-regulatory organizations, and that should just be part of the expectation.
Right, and part of that would require us to know that it's kids' content, right, and that there are kids watching it in order for those protections to work.
So I mean, the problem with behavioral advertising is not that it delivers sort of inappropriate content. I mean, we've been over this, but the fact that it aims to manipulate children and influence them in inappropriate ways, that's what, to us, the objection is. And I think the problem with inappropriate content, I think there's much more brand safety issues, awareness around this, and there's many more solutions from a different angle to look at that would be prevented. But that's not connected to online behavioral advertising.
I would just want to jump in there a little bit more to really go to that's really almost an editorial question, right? To like, what do we want our children to watch, either in terms of ad content or, which then also somewhat, I think, relates to what do we want our children to watch in terms of the content itself. And the approach that we seem to be taking here is to regulate that editorial decision through the privacy angle. My personal view is that we should address that, and we should address issues of curation, but we should do that head on and not necessarily just through privacy, but rather through a direct discussion of the question.
Can I, and I just wanted to echo what Harry said a little bit. I think that when we talk, we began this discussion talking about the privacy harms and the privacy aspect of COPPA, which I think COPPA is mostly about. But when we think about the ad side, I worry about undervaluing or undervaluing the information flows to kids. Just to say, well, they're advertising to kids, we need to stop it all. I mean, experience from my life, my world was changed when I was watching an ad and I saw Cookie Crisp. I'm like, wow, there are cookies. You can have cookies for cereal for breakfast. It was a game changer, right? But the point there is, like, if my parents would have seen that, or, we never would have had Cookie Crisp. Now, that's all I wanted to say. No, and I'm paid for by Cookie Crisp. But the point is, I think that I would not want to say, oh, you're under 13, so the decisions, again, we're kind of getting more into the realm of bigger picture policy of, like, who should have control over what is this a parental issue? But to devalue the information that flows to kids and say it's just completely valueless. I mean, the Supreme Court in Brown versus the video game case, and I can't remember.
Entertainment software.
Yeah, okay, yeah. So a couple, years ago, I mean, they said that, look, the kids, except for obscenity, and obscenity is usually defined in kind of pornographic terms or sexual, that the information flows to them, that kids shouldn't deserve any less First Amendment protection than grown-ups. That they're a vulnerable population, but they shouldn't deserve any. So I think that we need to be careful, and again, we're getting far afield from where COPPA is in the privacy issues, but once we start thinking about using COPPA as a tool to restrict advertising to kids, then I do think we're getting into First Amendment land, and we should think about, I mean, is COPPA the right tool for that? And we've had this debate, I mean, again, we're here at the FTC, which is sort of the best place in the world to be to talk about restricting advertisements to kids. And there's a rich history here of not a good one, eventually turned to a happy ending, I think. And I was here at the commission in the early to mid 2000s when there was a big push to do something with advertising for kids for obesity reasons, again. And that was kind of resisted a lot. And I know that there's research to suggest that kids don't get advertising, so everything's inherently deceptive, so that gets you out of the First Amendment. As far as I know, no court has adopted that, but the point being is that I don't think we should just give short shrift to information flows to kids and say that it's okay to have a rule that restricts information to kids. And that's kind of on the cost side. So when we have less valuable ads going to children, meaning, and I don't mean just the monetization, the reason that they make more money for the publisher or the content provider is because they're more likely to lead to action. And if, to the extent that kids are seeing fewer Cookie Crisp ads or things that they really could act on, and again, their parent is typically going to be the gatekeeper to this, this is something that should be valued. It shouldn't just be given short shrift.
Can I, thank you, James. Can I turn to one last question from the audience? I think we just have a few minutes left here. But the question is about persistent IDs, and it says, persistent IDs may be part of a child-directed site app, but may be on the device of the parent, so there may be multiple people using a shared device, and sort of how to address these types of identifiers. And at the same time, I wanted to bring in both Jonathan in his presentation and Dr. Radesky had mentioned that more and more kids now have their own device. Certainly wasn't true when the rule was revised. So if you can sort of meld those two together, any thoughts, welcome.
Sure. So I see, again, trying to focus on the computer science perspective, a great opportunity here for the commission to maybe encourage a new direction that addresses a lot of the issues that have thus far come up in COPPA implementation around kids have their own tablets, or maybe when they share a tablet now, Android, or I guess as of like a month ago, it's now called iPad OS, so iPad OS, have the ability to set up a profile specific to a child. And so were the world to move towards the operating system, for example, telling an app, and this is like technically trivial, the user who's currently on the device has a profile that their parent has configured as a child, and if the user is using your app or sending some sort of persistent identifier via your platform or so on, you should be COPPA compliant, and if you want to, in your exercise of editorial discretion, have child-friendly advertising and so on, you could do that too. I think that could get at a lot of the issues here. That, of course, does not solve shared devices, shared profiles on devices, but I think given that that seems to be where things are going, here's an opportunity to take advantage of the trend towards mobile devices and maybe solve some problems.
Yep. my opinion is that keeping the conventions of child-directed and actual knowledge is a cleaner way to recognize who is the kid instead of giving a more liberal look at who could be using a device. In practice, we often hear from an advertiser saying, well, we're trying to reach the family, and that's, the same as them sort of winking at you and saying, well, can't we get around this by just saying mom's probably in the room somewhere? That's how they try to get around COPPA. So if we loosen this up and say, well, a shared device with a shared persistent identifier is allowable, I think that gets us further into the gray than relying on what is good and more clean in, though, we've talked about it today, that could be even more clear, but child-directed and actual knowledge.
So I want to bring up a point that was made in a previous panel. How do you think these issues apply when you're talking about minorities and low-income families? Is it going to be just as easy for them to hit that button and say, oh, this is my child's device? What sort of issues do you see surrounding vulnerable populations?
So if I may jump in here, I think COPPA, when it was written, it was written in this tradition of privacy self-management, the idea that individuals make decisions, they're rational decision makers, if they have enough information, they can make this decision. And I think today we are much more aware, and we have growing evidence of the fact that predictive and classifying analytics really lead to a distribution of harms that look at groups of users, and that the distribution of harms is uneven, and that some people are more harmed than others, or groups of users, as particular people of color and low income. So COPPA identified children as particularly vulnerable, but I think even within children, we need to understand that there's different populations affected differently. And again, this is an area I think we need much more research on. We know this from the sort of the adult population. We've had some great research from Facebook and advertising and housing and employment, where even when advertiser wanted to reach a diverse audience, it ended up creating disparate impact. And so we think that, again, we mentioned the junk food marketing, but it could be problems the same in education, in other sort of areas where we need to look at the disparate impact. And I think, again, this is something for the Commission to look at in terms of 6B inquiry, because we cannot always see which populations which ads are delivered to which populations in the aggregate, and where the disparate impact is. And I think this is something we need to do a better job in representing these groups at this panel, in these conversations. If I look around the room at these panels, we're not doing a good job. We had one person this afternoon, and really, we are much more diverse, and we have in this country a growing problem of discrimination and increasing inequality, and we need to figure out to what extent the practices we're talking about today contribute to that inequality, and so we need to look at that.
On the issue of you have one device for a wide range of users, I would think that it would not be in our interest to disregard the signals coming from the child user, right? Because I think this is how the scenario where the erectile dysfunction ad ends up getting shown, right? It's hard to imagine now, but when we first got started on YouTube, there was very little information regarding anything on YouTube. It was in the earliest days. We were one of the first channels, and I uploaded my videos because I just wanted to email them to people. The concept of having a YouTube channel and publishing or developing audience YouTube was in no one's imagination. One of the reasons why we became active users of the platform was that in that environment where there was very little content on YouTube, for many of our videos, the sidebar thumbnail that was next to our videos when we first uploaded was a video about an exorcism. Okay, so I was using YouTube to share our videos with potential partners, and they would open it up, and you'd see the thumbnail and had this picture of an exorcism on it, and it just annoyed me to no end that, like, how could they possibly put this exorcism video against my video? And so I had no one to complain to. I had no recourse. One of the things that we realized that the only way we could get rid of it was by uploading more content, and in the hopes that one of our new uploads might replace that video. And it took us like, and that's the only reason why I started to like upload more content and start managing my channel, right? You know, obviously that would never happen today, but part of that is because they know that my content is kids content, right? If they didn't know my content was kids content, you know, what would, you know, and there, you know, there are enough problems, you know, as we know with some of the algorithms. So yes, I think we do want to consider those signals to help protect the kids.
Jonathan, did you have a comment?
I guess just to be, you know, extra clear on the issue of shared devices, I guess the direction I encourage the Commission to look at of potentially doing better with platforms enabling age gates and VPC and sort of ongoing parental relationships would have to be alongside dealing with the reality we all know exists, that parents hand their kids their smartphones and their tablets, and for some kids that's going to be the primary way in which they engage with devices. And so absolutely, you're going to have to look at other signals in those circumstances, right? You know, if someone installs an app that is clearly a child-directed app, the fact that the profile is not marked as a child profile is, you know, one piece of information, but maybe if it's just so obviously a child app, you can be confident that that's actually, you know, still going to be a child audience. Anyway, that is all to say there are issues that will exist alongside one another.
Right. And I think more options can always be helpful, but I do think that the current legal standard that exists today encompasses a lot of this and should stay the same because it's been workable, right? That you have actual knowledge, as Kate mentioned, either of the child's age or you have child-directed content. And I think that standard is important to continue maintaining because that has proved workable. And expanding it to, you know, require companies to guess or investigate more would really not be workable.
Well, with that, I see our time has expired, so I will ask for a quick hand for the panel, but then if you all would stay here, I will just give some closing remarks quickly. But thank you all.